Good afternoon, everyone. My name is Baldev Binder. I work at Blackstone and Co. And welcome to our webinar. It's been a while, and I've seen many new faces and many old ones as well on this webinar for force majeure in the Middle East. So unless you've been living under a rock, you will have noticed that there is a massive conflict going on in the Middle East, and the big central feature of its impact seems to be around crude oil and LNG. This webinar will give you background as to what is happening in the Middle East, where the practical bottlenecks are, how that translates to legal issues in the form of force majeure. And we're going to talk about very specific scenarios that we're seeing on the ground. Naturally, we can't give names, but hopefully some of the content that we delivered today would be relevant and would be quite highly topical for those of you involved. So let's set the backdrop. Why is there a crisis with crude? And I think many reports and newspaper articles don't really pick this up. There's a focus on crude and how crude is, the ability to lift crude has been impacted in the Middle East. There is a lot of reports on shipping not being able to go through the Strait of Hormuz. But why is crude so important? And I think this is an important diagram to put up for everybody else. Crude is the essential building block on which you then send to a refinery to refine products. You get gas oil, marine fuels, naphtha, jet fuels, a whole spectrum of fuels that come from it. And these fuels will move the wheels of our economy in many different ways. So it's not just a siloed issue to deal with crude. I think it is very much a widespread impact on the different products that come out from a refinery. I have to qualify this for those who are uninitiated. A refinery refines crude and produces this, refined products. Refineries might be in the Middle East. They've got refineries there as well within the Persian Gulf, and you've got refineries in Asia that buy quite heavily from the Middle East as well. So crude and its refined products are now in a bit of a bottleneck. We'll come to the bottleneck in a second, but the impact on crude affects all these different aspects which you see on the screen. The nature of force majeure, I think for the first week or first 2 weeks, there was a huge focus on shipping, and I think that's now cascaded to more of the international trade aspects of it. It's cascaded to different aspects of international trade. So on the top left of the screen, then this would be the initial issue that we saw at the Strait of Hormuz, i.e., insurers had withdrawn insurance coverage for war risks. They had increased premiums, and so vessels couldn't go past the Strait of Hormuz because there was increased peril, put it that way. With that inability of vessels to go and pick up cargo, what happened is that you had effectively a bottleneck. Ships were reluctant or hesitant to go into the Persian Gulf. I'll show you a picture of the Persian Gulf in a second. And at the same time, vessels who might already be in the Persian Gulf couldn't get out. So the consequence of that is that we saw a huge spike in freight rates because vessels were being effectively stranded around the area, not being able to move. There's also been, naturally, because vessels can't move, oil can't get lifted. Because oil can't get lifted, what you have is the crude that is being produced in the Middle East cannot reach Asian refineries, for example. And Asian refineries depend on this crude. They depend on crude. They also depend very much on the refined crude, for example, naphtha. When you have oil that cannot move, then naturally the terminal in the Middle East would start invariably reducing production. And when the terminal reduces production, that then creates a circular issue whereby you can't lift cargo, there isn't enough cargo to lift, and vessels that are trying to get there can't get there in time. And that's where we get into this huge mess. In the last week, we've seen even more issues happening within the Middle East with the terminals Ras Laffan in Doha was attacked. That's widely reported. You have Mina Al Hamadi in Kuwait. Just yesterday, we saw Iraq also declare force majeure from one of its gas fields. So you have this cycle of events happening. One aspect of it is the bottleneck with the straits, but now the facilities that produce crude and refined products are being affected. They're either reducing production because it's unsafe. They're reducing production because the oil that they're producing can't get lifted. And so you also have a storage problem. Now, bear in mind, we think of crude as I deliver crude, you come and pick it up. It's also an issue of where you're going to store the crude. If the vessel isn't going to be able to take the crude because it cannot leave the strait, then where does one store this crude? You can store it on shore in tanks. That's probably likely to reach its capacity quite soon. Or you can then start repurposing your tankers to become floating storage units, which opens a whole different can of worms when it comes to legal issues. The aspect we're going to talk about today would be what traders are facing when they are chartering vessels, what traders are facing when they're trying to pick up cargo from terminals that are affected. And we're also going to focus on something that I think should require more focus, and what I think would be the problem that's brewing in Asia. You have refineries that are affected in the Middle East, and you have crude that can't come out. So refineries in Asia are going to have a tough time to find substitute product. And the concept of a refinery, it's not quite a shop that you walk in and out of. I mean, refineries are optimized in terms of their feedstock coming in, how much quantity comes in, when it comes in, for it to then produce refined products. Now, refineries are in, you don't hear too many problems with refineries just yet, because sometimes I think the Asian refineries have got additional surplus or feedstock that they can rely on. But if the war drags on, I can foresee this being a problem, that Asian refineries will be looking to where they can get substitute cargo from. And that substitute cargo, it's not that easy. I mean, the Middle East cargo, sorry, to put it this way, Asian refineries, I think, are well optimized for Middle East grade crude oil. You can't quite get the same crude oil from other parts. So you'll have to go get US crude oil, West African crude oil, and then you'll have to probably factor in the time it will take. You'll then have to factor in whether you have to blend the crude oil to get to the right grade of original feedstock. So this is a moving dynamic feast. And the point of this slide really is that the dominoes when the dominoes fall, they fall across. So everyone's getting affected, from the terminal right down to the tankers, right down to the last person, which I would say, if you are in the petrochemical business, petrochemicals produce propylene and ethylene, and these are essential items that go into plastics. And plastics, as you and I know, go into every feature of our lives. So let's start with the basics of force majeure. I don't intend this to be a law school lecture on what force majeure is, but what I've put on the screen are some of the absolute critical parts of force majeure. Let me say a few headline comments. Force majeure, sorry, it's not a freestanding concept that you get. It is something specified within your contract. And as the interviewer at CNBC yesterday asked me, would it cover deliberate acts? And I think it's hard to give a uniform answer. Force majeure is specified within the contract. And so if the contract says you've been prevented because of war, because of blockade, then prima facie, at least on a default basis, it seems to be covered by that clause. The wording of the clause, I think, is the least of the problems. I think it's not so much a question of whether there is a war. The bigger question is, how has that war affected you, your contract, which in turn requires an assessment of your obligation. What obligation is it that has been affected? And we'll come to this in a second because it's very important. In international trade, you've got parties performing different obligations. And just a broad brush um, uh, allegation or assertion that there's war isn't enough to be precise enough to invoke force majeure. Because if this ever goes into a dispute, an arbitration tribunal will want evidence to show how that force majeure, how that war has affected you. And that's where we come into something like causation. Causation is that very fact of showing how something has affected you. And the point about causation, we've learned from multiple issues that have arisen over the past, I don't know, 20 years, right from the 2008 global financial crisis. The very fundamental point is this, is that just because a contract has become more expensive to perform, it has become harder to perform. It doesn't establish causation for which you can claim force majeure. Force majeure requires you to be prevented. And just because it's become more expensive, for example, you have to pay more for your freight today than you had to pay last month, that doesn't, in and of itself, entitle you to relief under force majeure. Causation is one element. I think one of the critical elements that you need to assess whether a force majeure can apply to you. The other aspect of it would be mitigation. And this is where I see a whole bunch of disputes happening, because mitigation is all about what alternatives could have been explored. And that is like highly, highly fact sensitive, which we can speak about. For example, mitigation could be what other sources of crude oil could you obtain? What other vessels you could secure? What other refined products you could have obtained, all within the contractual framework. The point about mitigation, I have to caveat this, is that it's qualified by this word reasonable. The law requires you to reasonably mitigate. It doesn't require you to go to the moon and get crude oil. It requires you to behave reasonably. On the one hand, while it requires you to behave reasonably, where if this issue ever goes before an arbitration tribunal, they will seek evidence of you seeking that mitigation, trying to get quotes, trying to get substitute cargo for those quotes. A very laid back, nonchalant attitude of saying, my suppliers passed me force majeure notice, so I'm passing it on. I just don't think that will cut it. That runs a huge risk, not least because, as I've said multiple times, your supplier's force majeure doesn't make it your force majeure, not automatically. That's a dangerous, slippery slope, and it's something that I think we'll come to when we're talking about the scenarios. The last 2 points deal with notice. Notice, typically you have in the contract saying if there's force majeure, you should be notified. And the last point is about the effect of force majeure. It's not a get out of jail card in and of itself. Different clauses, different contracts deal with the effect of force majeure differently. For example, those of you who are familiar, you would see that a lot of the contracts coming from Middle East producers have very supplier-friendly terms, whereby if there is force majeure, the supplier can terminate, or if it waits till the force majeure extends beyond the shipment period or beyond the period by when the vessel is meant to arrive or meant to load, then it gives the seller this right of termination, sometimes automatically a right of termination. Right of termination, it's one half of the coin. The next half of the coin is, okay, after you terminate, what's going to happen? In most part, if the clauses are silent, I would suggest that it means that the party who's been affected by the force majeure would need to go out and buy substitute cargo at a higher price, invariably. And that bill will come to the party that has failed to perform. And I think this is where a lot of disputes are going to arise, because we are at this stage of the force majeure charade, put it that way, where everyone is suspending obligations and they're saying, okay, we're just suspending performance. But at some point, someone is going to have to put his or her hand into his pocket and pay for that extra vessel, pay for that cargo. And once you do that, you're going to look towards your counterparty for a measure in damages. And that's where we're likely to see legal claims and the like flowing from there. So if I could hold on to this background of force majeure and ask you to remember 3 headline points. More expensive doesn't mean force majeure. Number 2, your supplier's force majeure doesn't automatically make it your force majeure. And number 3, it's not enough to say there's a war. I think what will be examined is what did you do during this period in terms of your mitigation. Let's take a step back before I bring you to the scenarios and how issues might arise in chain contracts. Let's take a step back and look at the basics of shipping terminology and trading terminology. You've got different trading obligations contracts. You've got FOB, CFR, DAP. FOB essentially means that the buyer needs to bring its vessel, in this case probably to the Persian Gulf, to lift cargo. CFR, on the other hand, implies that the seller needs to go and arrange for freight for cargo to be loaded and then sent to destination. FOB is load focus. CFR, while it's load focus, also looks at destination. It's more focused towards destination. It might actually be, they might actually not even stipulate where it's being loaded from and focus on destination instead. And then you have DAP. DAP is effectively the seller agreeing to deliver the goods at destination. And that would be the other extreme, whereby that obligation is undertaken by the seller to deliver at place. DAP is the person now most at risk, undoubtedly. All 3 categories are most at risk. But I raise this here because when I come to the chain contracts, I would like to show you how this breaks down. So when you think of your obligation under force majeure, think about one of 2 things. What is your shipping obligation? What is your delivery obligation? Where are you meant to load? Where are you meant to deliver to? That's your delivery obligation. The second obligation that you might want to think of is also the grade of product that you have agreed to sell. If you think about it, if you have contracted just for agnostic crude oil, as strange as it might sound, okay, then maybe it's not, it doesn't really, if you're trading agnostic, if you're trading crude oil to Shanghai by CFR, then maybe it is origin agnostic to that extent. But if you are trading Murban grade crude oil, Murban grade crude oil typically comes from Jebel Dana, which is inside of the Persian Gulf, meaning that it's affected by the Strait problem, or it could come from Fujairah, which is outside of the Strait. But you know, the movement of Murban oil from the field to Fujairah is by pipeline, and there are capacity issues over there as well. The reason why I talk about the grade is because when it comes to, it's important when you look at what the obligation is, what the causation is, and also what the mitigation is at some point. Okay, so let's break it down into the different scenarios. We have scenario 1 would be if you are an FOB buyer contracting to lift cargo from, let's say, the UAE. You've got the typical ports in the UAE. You've got Jebel Dana, Zirku, Das, all in the left side of the screen, which is the Persian Gulf, where the red vessel is. These are where the lifting points are. What you might have in this scenario is that the ship owner might say to you, who is the charterer, I'm not going to bring the vessel across the strait. It's too dangerous, or insist on high premium so that they can get the insurance coverage. In that situation, the ship owner's contract with you is through the charter party, but you have a contract as an FOB buyer with your supplier. You will also have a contract with your own buyer down, who might be an FOB buyer, might be a CFR buyer, might be a DAP, party, it could be any variant of this. The danger with FOB is that with any sort of shipping terminology is it's your laycan period. If you miss your laycan period, if you miss your shipment period in CFR, you run the risk of the contract being terminated in law. So that's a big danger over here. And so at this instance, if you're in the position of the FOB buyer, you tell your supplier in the Middle East, one of the major suppliers in the Middle East, I don't want to name names, and you tell them, I can't bring the vessel in. The first question you are going to get would be, can you not? Have you been prevented, or is it just more expensive? And the sub-issues towards that would then be, could you get another vessel? Are there no vessels that are willing to cross the strait? You could get an alternate vessel as an FOB buyer. You could pay that increased war risk premium. You could wait for a certain window for an escort transit if that is practical. Or the last point, which is quite unique in today's in the history of force majeure, you could take a different flag vessel, because bear in mind, I don't think the strait is closed for all and everyone. I think that there has been indications from the Iranian Guard that they would allow vessels of certain states to go by, and I'm quite sure vessels of certain countries are going by anyway. So these are all quite unique mitigation issues that will hit or impact the person who's claiming to be affected by force majeure. Bear in mind, the reason why I've shown the two vessels is because you might even have a ready vessel in the Persian Gulf who is ready to pick up, but can't pick up because it's got its own problems in terms of where it's meant to pick up from. And so it could possibly lift the cargo that you need to lift. Of course, then we're back to the circular issue. Once you go in, you also need to go back out of that strait. So that perennial problem arises again. Scenario 2 is about the CFR obligation. Now, CFR, typically a window would be, let's say, CFR March, Shanghai, for example. They might not put where the origin is, but they will put where the destination is. In that situation, what it means, I think that first line should be amended to say the ship must load by a certain point and head to destination. That's the main obligation. Now, loading might be disrupted in the Gulf, but a buyer might turn around and say, well, you promised me cargo in China. Go find a substitute cargo that you can give me in China. Go find another cargo that can load in the same window. And that is not an unreasonable request, but we have to view it in today's metrics. What are your alternatives? You could secure Middle East alternatives, which is other places that are not affected by the strait. You can look at the US, you can look at West Africa, but you've got to factor in the cost of freight, you've got to factor in the timing. And bear in mind, CFR, we're talking about a shipment, the cargo has to be loaded by a certain date. Now, just because I don't think there's a unique precedent for this, but just because you can load cargo in the US in March 2026 for destination China, I don't know whether that is effective mitigation or substitution for the original obligation of loading in the Middle East, simply because your transit time is much longer. So that's something that I think is quite unique. And bear in mind, the cost of freight is just has gone through the roof. I've got that number from ChatGPT. I'm not entirely sure whether it's correct, but it is a big number. Scenario 3 is the unique situation of some vessels getting in and some vessels not being able to get in. So this is a unique situation. If a buyer was to turn around and declare force majeure and say, I can't perform, or seller for that matter, one of the responses from a counterparty could be, well, you could switch to a permitted flag. You could get a vessel with a flag that that could make it work. Of course, this once again goes back towards the contractual window. And I say this as a unique situation simply because it's a case of mitigation that we're going to have to go round and round and really apply our minds to. And mitigation, I just want to temper it. It's still a case of reasonable mitigation, not crazy, unreasonable mitigation. If I could put all of this together and now show you where that problem arises within a string. And if you remember when I brought you to the basics of force majeure, and I said, what are the three things you need to remember? One of the things, the first thing was that more expensive contract does not mean it's force majeure. The second point is that your suppliers or your sellers force majeure doesn't automatically mean it's your force majeure. And I'm going to show you how that works here. In this scenario, we have a refineries/loading terminal in the Middle East. It's got a chain whereby an FOB trader picks it up from the Middle East, then might sell it to another trader who's selling on CFR terms, and somebody else who might be selling on DAP terms, all the way to the end receiver. And then end receiver might be a refinery, it might be a petrochemical company, who then sells the refined products to a downstream customer. The first force majeure that starts would be at the top of the screen. The ship owner, of which the FOB charterer has secured a charter, declares force majeure because war risk cancellations have happened. Now, that seems, if the charter party says that's a force majeure, then I think as a starting point, that seems legitimate. Now, can that FOB trader turn to the refinery and say, oh, sorry, the ship owner is not willing to cross, so I can't perform? Can the refinery legitimately look back and say, no, you go get a substitute vessel? Your job, Mr. FOB buyer, was to go and secure, to nominate a vessel and to pick up the cargo within a certain period. You haven't been prevented from doing that. One ship owner has prevented you, but show me proof that every ship owner has turned you down. That goes towards showing causation, goes towards showing mitigation. So that's a key factor over here. Now, if you are the middle guy, the CFR trader, and you've promised your buyer that I'm going to get cargo to Shanghai by end March, okay, the pushback to you would then be, what's stopping you from getting substitute cargo? Must it come from the Middle East? Did you specify that you wanted Bourbon grade or grade of oil that is only found within the Persian Gulf? If not, what are your attempts at getting substitute cargo? Your job is to get cargo, put it onto a ship for destination China. Show me you have been prevented from doing that. Not just more difficult, not just more expensive. Show me you've been prevented. And likewise for the DAP trader as well. Same problem arises over there. The pushback can still be legitimately made that they should go find substitute cargo. So the one problem arises from the start, which is the ship owner having a legitimate force majeure, which does not translate to a force majeure that an FOB trader can use. And the FOB trader's force majeure, even if it can be used, might not translate to the CFR trader's force majeure. That's one thing to bear in mind. Another thing to bear in mind, quite importantly, in this flow of contracts, is the way oil is contracted for. You have got deal recaps, 2-3 page contracts with the main terms, buttressed and bolstered by the GTCs of whoever has the more leverage, I suppose. So on the one hand, I've always found this interesting with international trade. On the one hand, if you are the FOB trader buying from the refinery direct, undoubtedly you are going to apply the refineries or the loading terminals GTCs, the producers GTCs, which might be very seller friendly. For example, you might have clauses in that sort of GTC that says the supplier, the producer, can unilaterally reduce supply, can reduce supply by 10%, by 20%, maybe by any broad number as well. Does that same obligation, or sorry, does that same right transfer all the way down? And the answer is that not always. This idea of back-to-back trading, I think, is sometimes a misnomer because at the one end, you might have a big receiver who's dictating things on his term. So someone in the middle is caught with an asymmetrical contract whereby their deal recaps might have amended force majeure terms or cancellation terms or reduction terms. And so while the refinery on the left side of the screen might possibly legitimately declare force majeure under its trade contract, does that reduction in supply translate all the way down? So I come back to that starting point again. The dominoes fall, but do they fall equally for everyone in the chain? And the answer is possibly no. If the trading contracts are not aligned, if there have been amendments to the deal recaps that are not back to back, and if the intermediary parties can't show causation that they have been affected by this, and their mitigation will be completely different. Refineries mitigation, because it might have such strong rights to reduce, will unlikely to be the same mitigation metrics that it would be for the CFR trader in between or the DAP trader. So causation and mitigation, not one size fits all for all the people in the chain. There are going to be problems. I'll go even as far to say the refinery that cuts production, cuts supply. You might see pushback as well. I mean, you might get a buyer saying, well, show me you've cut supply for everyone. Is it just me? Why just me? If you say this has been affected by the war, you've been attacked, that's why you have to reduce it. Show me you've applied it across the board to all your off-takers. So the evidence to show the treatment that you're given across the board, I think that's really quite important. And that will, if there's one thing you take away from this webinar, I hope that's that it's not a case of just lying back and saying, oh, producers declared force majeure, let's pass it up the chain or let's pass it down the chain. It's a lot more tricky than just that. I think you'll have to apply your mind as to what more you could do, what more you could have asked of your counterparty, whether they truly were affected, what more could your assessment could be in terms of how you were affected as well. Let's go to scenario 5, which is, I think, what we've just spoken about, actually. Supplier refiner production cuts. So production cuts might happen. I wouldn't say will happen. Might happen for two reasons. One being storage constraints. If vessels are not lifting cargo, where are you going to put that cargo? So you might reduce that production. Secondly, I think we're seeing increasing attacks on terminals itself. So I wouldn't be surprised if production is cut. For example, I believe the reports on the news says that Ras Laffan, which is in Qatar, that they were attacked, and so their production facilities, if I read right, something like 17 or 20% of their production facilities of their output has been affected, and it will take them 5 years to actually rectify that. So that's pretty huge production cuts that goes across. The production cuts might happen for crude, might happen for refined products, and so it will go down the chain of affecting other refineries in Asia who are reliant on Middle East cargo, and also petrochemicals who are reliant on naphtha as their feedstock. So the reality of production cuts would mean that it wouldn't surprise me if the suppliers had very broad unilateral rights to cut, as I mentioned before. But the impact really is on the buyer. And once again, the buyer, I think an arbitration tribunal will be quite unimpressed with the buyer who just sits back and says, someone up the chain has cut. And so I'm not going to do anything. I'm just going to sit and wait till it gets lifted. Now, also bear in mind, production cuts, it's the idea of force majeure for production cuts, it's unlikely to fit neatly within the idea of force majeure. Force majeure means that you've got a window of relief. There's been a suspension of your rights for a certain period. Production cuts to me sounds a bit more than just a temporary suspension. I think production cuts would probably really affect the ability to lift cargo this month, next month, for example, because once again, it's not like a tap that you can just switch on and switch off quite easily that way. Let's go to petrochemicals. If you've read the news, you'd see a flurry of petrochemical refineries who have declared force majeure on their downstream buyers. A large part of it has to do with naphtha. Naphtha is the main feedstock that a petrochemical company would use to then produce, as I mentioned, propylene and ethylene, which goes into plastics. These plants are very reliant on specific grades. So there's going to be a bit of disputes over here, I think, because naturally the refineries will be challenged as to what mitigation did they do. Could they have substituted feedstock? Could they have imported alternatives? And I come back again to the point that you're not meant to go to the moon and secure an alternative. The law requires you to behave reasonably, but that justification needs to be there. An attempt to secure feedstocks to say, okay, if I was to get naphtha from the US, it would take too long to arrive. That's why I need to declare force majeure now if I'm a petrochemical refiner. There needs to be that rationale behind it. And I think the more evidence you are able to demonstrate, the better your position would be if you ever end up in an arbitration about this. This is a diagrammatic representation of the petrochemical situation. It's just to show that disruption in the Middle East means crude can't move. Crude can't move means refined products like naphtha can't be produced, whether in the Middle East or whether in Asian refineries. It's mostly in the Middle East, if I understand it right. I think naphtha used by Asian refineries is mostly, they are heavily reliant on Middle East naphtha. And when that is a problem, then you're going to have force majeure notices declared downwards. And that same headline concern applies equally with petrochemicals. The difference, I think, why petrochemicals have declared force majeure quicker than Asian refineries, I think, is because of that heavy reliance on naphtha. And Asian refineries, I think, are able to have, they would have additional surplus, emergency surplus that I think they can use for now. But the question is, for how long? Scenario 7, I think we've got 2 more scenarios before we wrap it up and take some questions. Scenario 7 would deal with the inevitable situation of storage saturation. To repeat once again, oil tankers can't come and can't lift up cargo in the Persian Gulf. You've got a bottleneck over there. Producers might cut their output, and so whatever oil there is would have to be stored in onshore tanks, and that might mean that terminals start telling traders, no, you cannot put your oil, you cannot put new oil, you cannot put your cargo into my tank because we're filled up, because it's a force majeure on their part. It's somewhat unique, but there's a possibility of that happening. We haven't come across it ourselves, but logically, I think there's a possibility of it happening. You then have the repurposing of vessels into floating storage, and that, as I mentioned, carries a huge bunch of risk. I think commercial and also practical at the same time. Commercial being your rates when you hire a vessel, you're hiring on a voyage to time basis. When you're doing it as a floating storage, so it seems to be a different metrics to be used for that. The questions of mitigation will arise once again, whereby you are asked, how are you, did you need to store it onto a tanker? Could you not have diverted it to a different terminal? Could you not have reduced or taken other alternatives up in this meantime? LNG, which is scenario A. LNG, I used to do LNG a long, long time ago. And what I can tell you about LNG is that it is a unique product by itself, quite different from crude. And I think the contracts of LNG are also quite different from crude as well. It's a structured contract. The market for LNG, I would say is not as liquid as crude is, and so this creates an implication. The implication is this: it's for most part, for the longest time, I think, LNG was bought primarily from the utilities companies in North of Asia, who are buying from different producers directly. And I think that's where you have less of that chain issues that are identified with crude, because you have a direct mechanism. But before I go into that, but that's just the background of LNG. I think you also have the possibility of buying from aggregators or portfolio suppliers who aggregate LNG from different sources and then sell it out. What's happened with LNG? I cannot stress how severe the situation is. If Qatar declared what they declared and said that their liquefaction facilities are affected, they expect 70% of their production to be affected, and that is a huge amount of global LNG that is now there's a question mark as to where one can get that source from. I would be more surprised if the producers who've had their terminals attacked cannot rely on force majeure. I'm quite sure they would be able to, depending on what their wording is. But the issue now is for the counterpart. The counterpart could be a middle trader. It could be a utilities company that is buying for its own use. And it's now in a real dilemma because it needs to figure out where to get LNG sources for. And it's not something that, as I mentioned, not something as liquid as crude where you might be able to substitute it. I think there are a huge amount of practical considerations when dealing with LNG, both in terms of logistics, but also in terms of timing at the same time. So, what else can we do when force majeure fails? Force majeure, if we take stock of where we are with force majeure, I think my observation of it is that people are quite quick and treat it a bit too casually in terms of passing force majeure notices up and down. There seems to be a fundamental misunderstanding or misapprehension as to the requirement of, as I mentioned in layperson's terms, to be able to show how the war has affected your obligation. And your obligation is the part that really should go into your force majeure notice, saying, my obligation was to do this, I can't do this now because of the war. It's, in my mind, not sufficient to simply say, my suppliers declared force majeure, my supply might have a completely different scenario from what I'm in, but my supplier's force majeure is my force majeure. And that is a slippery and costly position to take, I think, if it was to go into arbitration. So what are the alternatives? If, for example, you find that you can't deploy force majeure, what other alternatives do you have? Not much. I've put these alternative doctrines on the slide over here, but I'll be honest and tell you that it is it doesn't happen that often. The most common is frustration under English law. Frustration implies a situation where you are unable to perform the contract, or it's impossible to perform the contract. For example, the subject matter has disappeared. the whole vessel has just disappeared. Or the whole terminal has disappeared. So if you were meant to buy from terminal X and that terminal X no longer exists, okay, you might have grounds to say there's frustration. It's not, you can't deploy frustration in situations where mitigation, where reasonable alternative is there. I think that's quite difficult then. To give you how hard it is to succeed on frustration, I have done law for more than 20 years. I've never seen a case of frustration succeed. So I think it's something for extreme situations, and generally speaking, I don't see it applying just yet on present facts. Of course, each case turns on its own. You have also the American doctrine of commercial impracticability, and that's something that it's also a difficult doctrine to apply. It's not something that you get to apply it by virtue of picking US law as your governing law, which may or may not be the case. If it's not the case, then that doctrine goes out the window. But in large part, these arguments are what I call bottom of the barrel arguments. When you are deploying them, it is the furthest thing from a show of strength and a furthest thing from a compelling argument to make before an arbitration tribunal. So there are these doctrines. I just think it's going to be a long shot to be able to use them. I am keen on taking questions, and I think we've got about 12 or 13 minutes to go. Let me conclude with this slide. So what should you do as a trader? And this is I guess this is what you would see all law firms rolling out this sort of material. But let me focus on the practical aspect, and I think it's documenting your mitigation efforts. That is, to me, highly key. It is don't make the foolish mistake of just piggybacking off somebody else's force majeure. Consider how the war is affecting your obligation, and by doing so, I think consider what your alternatives are. When you have alternatives, then I think your mitigation starts taking shape. When you're sending force majeure notices, there's always a temptation to just copy whatever has been told to you and then pass it on or down the chain. But I think if you apply your mind as to how the force majeure is affecting you, you are less likely to then get challenged. If you sit back and say, my supplier is declared force majeure, so I'm declaring force majeure, I think the knee-jerk reaction would be, well, show me how is it affecting you. Show me what you have done or what you couldn't do because of this supplier force majeure. So that is towards the end of the webinar. I'm happy to take questions. I left 10 minutes out to take questions. We have a risk report that we prepared earlier this year, which deals with a whole bunch of different things, including sanctions and force majeure claims, because it's not that I had a crystal ball. I think it's just that the way the world is going today, you could see that geopolitics and trade dislocations are going to be the common theme, as they were in the past few years, particularly with the Russian conflict and with the COVID outbreak affecting ports. So if you'd like a copy of the report, I've put up a QR code for you to scan that. And of course, we're happy to send you a copy of the slides. So I am more than happy to take some questions. Let me just see if I can give me a few minutes to pull up the questions. Anyone's got any questions? Oh, no questions yet. Okay, I must be extremely compelling for there to be no questions. Oh, here we go. Yes. Okay. The question is, if you have a trade financed by an LC, but delivery is prevented and force majeure declared, what are the implications for the payment obligation under the LC? Good question. Okay, so LC, I think, follows very much the requirements under the LC. So, for example, the LC says, I will pay upon presentation of a PL, meaning cargo has been loaded. That's it. You pay. It's if the cargo has been loaded, the conditions for the LC has been triggered and payment has been made. It's the LC has very little interest as a payment instrument to look into issues of force majeure. It is purely a payment instrument that says, I will pay on performance A, B, and C being done. And A, B, and C being done, just to be clear, for LC payments might not be that the cargo has reached destination. Typically, it would be that you present a BL, which means that at the very least the cargo has been loaded. So if the cargo hasn't not been loaded, for example, the vessel can't get past the strait, then okay, the terms of the LC hasn't been made out. The seller hasn't demonstrated it's fulfilled its obligation, and so the LC doesn't seem to be triggered. But if the cargo has been loaded and the certs are there, the documents are there, then voila, documentary compliance. I think the LC has to pay. I hope that answers the question. Anybody else, feel free to ask. Okay, another question on, can banks declare force majeure to refuse transfers from bank accounts? I have no idea. That's completely left field question. I think that very much depends on what the banking terms are. I'm guessing maybe, I don't know if the bank is in Iran itself, then yeah, perhaps the bank is closed because it's physically unable to move the funds. But otherwise, I don't think it doesn't strike me as particularly compelling. Another question, which is a good question. Why do charter parties often have no force majeure clauses in them? That's a very good observation, and I don't have an answer to that. I know that's the case, I think, and I would suggest that I think the issue of the reason why force majeure clauses have come about is because for the trading chain, which is a horizontal chain, you're dealing with GTCs, and GTCs of a big producer or a big buyer on the other end. So both parties tend to want to put in bells and braces approach towards having all sorts of clauses, including force majeure clauses. But charter parties tend to be, at times, tend to be quite fast and loose, and they tend to be chopped and changed from different forms as well. So I guess it could be, I'm just guessing, I guess the adherence to it, or the discipline, the adherence to a more structured, dogmatic form of contracting is less common with charter parties. Another question. You mentioned the potential for arbitration. Is that a typical route for disputing a force majeure claim by a trader? Yes. So in most parts, international trade contracts, so the force majeure itself, it's unlikely in and of itself to then trigger an arbitration notice. What normally happens is this. International trade contracts typically contain arbitration clauses. You bring an arbitration claim typically when you have suffered a loss. You have got to crystallize that loss. You don't have to, but you should crystallize that loss before you bring that claim. So what happens in this suspension period that we're in? Everyone's sitting back saying, I can't perform, let's wait and see, let's see if it opens again. And bear in mind, particularly also for the LNG business, but also for oil, these parties have a long history of trading with one another. It's a very relational party context. And so they're not quick to want to bring arbitration against one another. But as I mentioned, at some point, the force majeure is going to tick over to a termination. That termination is going to require someone within this chain, if we go back to that chain again, someone within the chain to go into the market and buy substitute cargo. And one of these actors in this chain, once they have suffered a loss, meaning that they have bought cargo now at a much higher price than what they originally envisaged, then they will bring their claim down the chain. And at that point of time, it is too late to then concoct up your attempts to mitigate, to concoct up evidence of force majeure that you got from your supplier. You've got to have that discipline to have that evidence now. I cannot stress how important that is to have that in place now. I'm happy to take one more question if there is. Open to the floor. Okay. If not, forever hold your breath. Yes. So I will end today's webinar with this parting note. If I could summarize what we've been speaking about for the past hour. Force majeure notice, there are 3 essential points you want to remember with them. Think about what your obligation is that's been affected. Think about the causation, how you've been unable to perform, knowing that a more expensive contract is not an excuse to not perform. And the third point is look at your alternatives. And there are alternatives, but without any evidence of securing alternatives, without any evidence of mitigation, it looks quite unfavorable for a party to then subsequently seek relief of a court of law for force majeure. If there are no other questions, I hope you've enjoyed today's session, and we will send the slides across. If you have any questions, you know where I am. Feel free to get in touch. Thank you, everyone, and have a good day.